Hello, everyone. Welcome to the webinar, The Top Tenant Must Have Lease Clauses. These are the lease clauses that tenants must negotiate. During this webinar, Peter Morris and I will be discussing the most important lease clauses. We will explain, among other things, why these lease clauses are so important, how to distinguish the most important terms from those that tenants can give up, how the type of property you are leasing can affect the degree of importance, and some additional COVID-19 considerations. So why don't we begin? Let me introduce myself. My name is Howard Klein. And Peter Morris, you should be seeing Peter Morris to my right, hopefully. This webinar, I want to make a point, is for landlords, tenants, property managers, and any other business that has any relationship to commercial real property. It's important. This is just as important for landlords as it is for tenants, because landlords really need to understand these clauses in order to protect themselves and in order to be able to negotiate the best deal, because these are the clauses that tenants are going to be focusing on. Peter and I are not providing legal advice in this webinar. Our intent is to educate and inform. With this said, we encourage you to contact us for assistance. As such, this may be considered attorney advertising by me. Since Peter's not an attorney, it won't be. The information we are providing and the clauses that we are mentioning are not exclusives. We can't include every clause that has some importance to tenants. Depending upon the circumstances, there may be other clauses that are of more importance to particular tenants. Let me also mention that Peter is offering a 40% discount for his ebook Master Guide to Leasing for Retail Landlords. Since this is a re-recording, we're going to leave that offer open for additional 24 hours, and it's limited to the first 20 people who order. Finally, in the right side of your window, you should see a section called File Handouts. In the re-recording, I'm not sure that you'll be able to do it, but on my website, CRE Radio, I will make the handouts available for download. So let me now introduce Peter and I. So let's move on. Okay, before we do, let me mention this. You miss 100% of the shots you don't take. I've heard Michael Jordan say that, and I've heard that this quote has been attributable, or similar quotes have been attributable to other people. The point of that is, since we're talking about these are the clauses that tenants must negotiate, if you don't raise these issues, then you can't win on these issues. And that's the point. Everything is negotiable. Don't be afraid to ask questions and make a point of some of these issues. So now let's move on to Peter and I. So let me start with Peter, since he's to the left. Peter is an internationally known author, educator, and real estate consultant. He is the founder of the Greenstad Consulting Group, which is based out of Vancouver, BC, Canada. And he is also, as an educator, he trains commercial brokers. They also offer both landlord and tenant focused lease advisory and management services. My name is Howard F. Klein. I've been an attorney for over 40 years, primarily focused in commercial landlord-tenant matters, including lease negotiations, rent collections, and eviction. Peter and I Peter gave me over 20 lease clauses that he felt were the most important to tenants. I had to pare it down to something that I felt were the clauses that were in most of the leases, and I chose the top ones. There's Peter came back. He'll be coming in and out, chances are. Probably his internet connection out of Vancouver. So let's start out. I'm just going to mention, before we go into, the top 6 clauses are use clause, assignment and subletting, lease term and options, CAM charges, operating expenses and utilities, premises definition, and incorporation clause. And we will go into more detail in explaining these. So, Peter, why don't you start out talking about the use clause?
Thanks, Howard. So landlords would want, particularly in retail properties, to have a very narrow defined use clause. This helps landlords with their merchandising. It's a little less important in office and warehouse industrial. It's still important, don't get me wrong, but a little less important. Now, the benefits to the landlord of that is that they can deal with the individual use. The problem for the tenant, if it's in retail, for an example, it could limit where you could sell your business to. It can also have the same effect when it comes to office tenants and warehouse industrial tenants. So from a tenant's perspective, the tenant wants the use clause to be as broad and wide as possible. In an ideal world, it would be for any legal purpose. I actually was working with a franchise restaurant franchisee yesterday. I went over their lease, and their use clause was quite simple: a licensed restaurant. Well, that's almost ideal. And the reason I would say that that's going to work for him as compared to any legal purpose is the highest and best use of that space, because it's fitted out specifically for a restaurant, is probably another restaurant. But he doesn't want to be hemmed into, say, if he's doing pizza and pasta and Italian, that he could only assign the lease to another operator of pizza, pasta, and Italian. Maybe the new owner wants to do Middle Eastern. Maybe they want to do hamburgers and steaks. So from the tenant's perspective, it's very important to try and get that use clause as broad as you possibly can. But understand the landlord's going to come in and try and get that very narrow. For offices, kind of the same thing applies. You see on the screen, the words law office. And as Howard frequently points out, that's a specific use. So if the law firm wants to sublease or assign the lease to somebody else, right now it could only be for a law office. Well, what does that do? The landlord might say, yeah, we'll change the use, but this is what it's going to cost you. So you want to keep all the leverage that you can possibly get. And that's just to touch on a very high level. Howard?
Yes. Well, I don't have any comment at this moment, but we're going to get to the assignment and subletting clause, and we will draw the nexus, the very tight nexus between the use clause and the assignment and subletting clause. So why don't we talk about assignment and subletting and its relationship to the use clause restrictions?
Let's start off with understanding what is the difference between an assignment and a sublease. So in an assignment, the original tenant is saying to the landlord, I have a new tenant, they're going to take over all of my obligations and I'm going to step to the side. That's an assignment. In a sublet situation, what the original tenant is doing is they're saying, I am going to let someone else operate within the premises, but I am still the head tenant, or now called sub-landlord. So the lease doesn't really change. So if your use clause is for pizza and pasta, for an example, your subtenant must do pizza and pasta because that covenant flows through to the subtenancy.
Let me interrupt you for a second, because
Sure.
there's a legal consequence between an assignment and subletting also. Generally speaking, when a tenant subleases to a subtenant, that the original tenant is likely to have the right to evict the subtenant. Mm-hmm. So there are legal rights to possession that are not given away permanently, where in an assignment, usually, and again, it may vary by jurisdiction, but usually the sub-landlord or the tenant in an assignment will not have the right to evict the subtenant. only the well,
Landlord.
in an assignment, it's not a subtenant, it's an S&E. So let me clarify that. So only the original landlord would have that right to evict the S&E.
That's very
That's a
true. And
clarification.
that's really important. And you bring up various jurisdictions. So let me go off on a little bit of a tangent here for 1 second and say, although I'm based in Canada and Howard's based in the United States, what we're talking about generally are general concepts. So as Howard mentioned, they're going to change a little bit by jurisdiction, but the general concept pretty much holds throughout all of North America, most of Europe, and in many parts of the Asian subcontinent as well. But the other thing about an assignment that I think is important, other than the use clause, and we've touched on that, is from the tenant's perspective, you have to watch the wording very, very carefully, because in most assignment clauses, it says that the assignor, even though they're not a party to the lease on a daily basis anymore, remains liable for the performance of the lease by the assignee. So the issue with that is that if you don't make it time limited, in other words, to this particular assignee, an assignor, the original tenant, could find themselves liable for all the knock-on tenants that come into place later with future assignments. Landlords love that concept because it allows them to go after many, many pockets rather than one pocket if something goes wrong. But from a tenant's point of view, how would you feel if you got a notice 20 years after your assignment saying that you're responsible for people you've never heard of before? So it's very important to make sure that you lock out that kind of knock-on effect.
Peter, there was a question to me, I think, in the original version of this webinar as to whether or not you should put in the original lease, as part of your original negotiations, a limitation of liability in the case of an assignment. In my position, certainly, I just don't think that that should be negotiated as part of the original lease. I think that you simply allow whatever the jurisdiction provides for, and if the tenant later is in the position to negotiate or want to negotiate an assignment, that's when I think that the limitations of liability should be negotiated. And all of that will depend upon the leverage that the landlord and tenant have, some of which may be based upon what was originally negotiated, the other assignment and subletting terms that were originally negotiated. What are your thoughts on that?
I agree with you. The more things that you bring up in the original negotiation, the more things that, could go wrong. And depends upon leverage and things of that nature. Sometimes it's best to hold your cards. And I would say, if you're looking at an assignment and the landlord says, I want you to be liable for subsequent assignees, now's the time to limit it at the time of the assignment. It doesn't need to be upfront. However, if you want to have it that the assignor is not liable for the very first assignment, and I've seen that happen, then you want to have that as part of the original negotiation. But it brings up an interesting point. What is a transfer? So when an assignment occurs, what is that transfer? Well, a transfer can be any number of different things. Most people think of it as just the sale of the business from one party to another, and they would transfer the lease accordingly. Well, the transfer could be a share sale. It could be if you have partners, and I've seen this occur as well. If you have a partnership and two people, sake of argument, and one decides to retire, the other one buys them out, guess what? That's an assignment of lease. So you're going to have to go to the landlord for that. Landlord might have other provisions in the lease that says, for an example, that the option to renew might be personal to the original tenant and not to any assignee. Well, that becomes a big problem in that particular example that I just gave you. So you have to be very, very careful about thinking through the assignment process. And my comment to tenants is this. When you walk into the lease, think about how you're going to walk out of the lease at some point in time in the future and map out what it is that you want. Howard and I constantly say, before you go into the negotiation, prepare. Think it through. That's all I'm saying.
Yeah, there are a couple of other terms in the more sophisticated leases. The landlord is basically trying to control the property, control the lease for as long as possible. So that's where the use and assignment and subletting clause often comes into play. So in situations, and I have done this, where there was a one paragraph assignment and subletting clause, what we would often do when I represent, well, in a number of occasions, I have dealt with this situation where there was no prohibition on a change in the management or control of the business. So what we would do is the purported assignor would not do an assignment. What they would do is they would sell all of the assets of the business rather than the ownership. And then we would do a license agreement to manage the business within the premises. So for landlords, if you go, look, I don't want to bog everybody down with lots of language, so I'm going to put a one paragraph assignment and sublet clause in there. Oh, you're not going to be a happy camper. And there are all kinds of ways. So on the more sophisticated leases, you see provisions that a transfer occurs upon a change in the management or control, or a change in the percentage ownership or control, or a sale of the assets. And just talking about the sale of the assets, you also have a situation where some landlords will attribute a certain percentage of the sale of the assets to the value of the lease. So if you owned a business, in a case, let's say you have a vocational school and you sell the vocational school, all of the assets, management, control, license, and leases to the buyer, the landlord, depending upon the language of the lease, may be able to say, that $1 million that you just received, 500,000 of that should be valued in the lease. And in some of our cases that we got away with this, it probably was. We were more interested in the lease. In some cases, we had no interest in the lease. We were interested in the license to run a vocational school. That's where all the value was. So those are some of the things that you might want to take into consideration. I don't know if Peter is back.
Go ahead, I'm back on audio only here for the moment. So one of the other things that you should consider, and I work with a lot of franchisors, that in some cases, and even if it's just an independent business selling the business from one to the other, depending upon the wording in the lease, it could be so broad that the landlord could say, oh, the value that you got for that business, or your royalty fees, or your original franchise fee. Well, I get that because that's the overage over and above the rent that you'd be paying me. Very akin to what you were just talking about. So you have to be careful to exclude those kinds of things. It's probably not intended that way, but a good intention doesn't mean anything if it's not in writing, is a saying that I like to have. Don't use common knowledge, because common knowledge is going to trip you up every single time.
It's not so common.
Exactly.
Nor is it knowledge sometimes.
True. The other thing is that you should resist the landlord's right to terminate the lease just because you bring forward an assignee or a sublet, because the landlord could potentially look at that and go around you in order to cut a better deal with the other person, cutting you out of the deal altogether. Now, the only good thing with something like that is any liability that you would have would also go away. So the issues, maybe not the personal guarantee, but the liability as the tenant. So just be careful of the wording is all I'm going to say at this point in time.
Let's take a slight step back and talk about landlord consent, because in nearly every lease that I've seen where there's an assignment or sublet, the landlord requires its consent. But it varies from jurisdiction to jurisdiction, and it varies from lease to lease. And now let me give you some examples. And what we're talking about here is whether or not the landlord could withhold its consent in its complete and utter discretion, or whether or not the landlord has to act reasonably in terms of giving or withholding its consent. Now, years ago, going back maybe 10 or so years ago, in California, a landlord could not unreasonably withhold its consent, no matter what it was written in the lease. That has now changed. And I'm going to use California as an example because I'm familiar with California law. California changed the law that said, okay, the landlord can now withhold its consent in its utter and complete discretion as long as it says that in the lease. But there are ramifications if the landlord does that. So in California, if the landlord for some reason terminates the lease based upon the tenant's breach, the landlord can often sue for rents through the remainder of the term of the lease. I'm not going to go into that kind of detail what the various remedies are. But in the case where it has the right to withhold its consent in its complete and utter discretion, it may lose that right to sue for future rents. Mm-hmm. So often in the more sophisticated leases in California, what the provision is that the landlord will not unreasonably withhold its consent, but the lease lays out what the guidelines are for what is considered reasonable. And in those situations, if the landlord withholds its consent and follows those guidelines and the tenant then breaches, it is entirely possible that the landlord will be able to sue for future rents. So withholding its consent, having the right to withhold consent, it affects the liabilities and obligations on a going forward basis. The other thing is in California, excuse me, if the tenant assigns or subleases and does not get the landlord's written consent, the landlord, excuse me, the landlord can terminate the lease by serving a notice terminating the lease, and it's not optional. Yeah. It can't be cured in California. And so that's something else.
I'll let you have a sip of water there, Howard, while I also mention that your comment about reasonable and what is reasonable or unreasonable and putting out what is reasonable within the lease is also, although Howard's talking specifically on California, applies to all of English-speaking Canada. So because reasonable is a legal term. And if you go to court, I'm not a lawyer, but if you, Howard, you can back me up on this. If you go to court and it says reasonable, you have to prove what is reasonable. So what landlords are doing is saying, well, look, we'll just take that whole argument out of court and have someone else decide. We're going to contractually decide now what is reasonable and what is not reasonable. So again, when you're looking at something like that, now's a really good time to make sure that you engage a really good commercial lease lawyer. And I will tell you right now, I say this over and over and over again in my training whenever I'm talking to somebody, don't look for a real estate lawyer because they could do house conveyancing and have never touched a commercial deal. Don't even look at a commercial real estate lawyer. Look for a lawyer that specializes in commercial real estate leases, particularly of the asset class that you're talking about, because they are going to be familiar with the kinds of laws that Howard's talking about, because these things change all the time. One other quick thing that's different, and I will mention this specific for the province of British Columbia, it does not apply necessarily anywhere else, but something you should be aware of, is that due to bankruptcy law and what happened in bankruptcy, there is a little nuance between sublease and assignment in British Columbia, and that is, in a sublease, the sub-landlord, the original tenant, has to reserve some part of the lease to itself for it to be a valid sublease. And in most cases, it's the last day of the term. So if the term was to end on June 30th, the sublease would end on June 29th. And it's just a quirk relative to bankruptcy laws, and it came out of a major department store bankruptcy in Western Canada. So I want to mention that because if there is no reservation, it could be deemed an assignment, which might trigger some other problems. Let's continue
and I
on.
think, Peter, you had mentioned this before, but I want to stress this point. Generally speaking, if you are an assignor, you're in a terrible position.
Yeah.
Unless you negotiate because you've got no rights whatsoever.
Yeah.
And it's a difficult position to be in. So when you're in a position to assign a lease, that's the time that you really need to start your negotiations. Let's move on to another provision that's very important, the term of the lease. And let me start with a typical problem that I encounter, usually after the fact. People get confused between lease commencement and rent commencement. And in that problem that arises, it really needs to be clear when the lease commences and when the rent commences. So let's talk a little bit, and we'll get into more detail on this. Peter, why don't you talk about free rent versus early possession and how it affects the term of the lease?
There's a couple of things that come into play here, and I'll add one more date to what you just talked about, Howard, and that's the effective date of the contract. So the effective date of the contract might be one date, which is when you sign the contract. The lease commencement might be at another date, perhaps after the landlord has done landlord's work, for an example. And then rent commencement will be at some point in time in the future after that. So there's a couple of ways that landlords will do this. One way that they'll do this is they'll set up a period of free rent after the lease starts running, usually a fixturing period, and that can be anywhere from 30 to however long you can negotiate, typically no more than 180 days. So the lease is started, everything's going, and then you have a period of time that burns off called the fixturing period. Now, if there's another part to that clause that says it's going to end on the earlier of the store opening or the office opening or the warehouse opening or the end of the, let's say, 90 days. If you are not ready to open and you've blown past the 90 days, you're into 120 days, guess what? You just paid 30 days of rent with absolutely no premises that you can operate from. So that's a bit of a problem there. So you have to make sure that you build all your dates in properly when you're doing your negotiation. The next one is early possession. And in early possession, it says, look, the lease won't commence until you open, but we'll allow you to come in early to fixture. The problem with that
let me correct you on that. The lease actually starts on a set date, and we will let you come in early.
Correct.
And that affects everything else down the line.
You're 100% correct, and I said it incorrectly. You know, it would be we're going to have an opening date of the business on such and such a date. You're quite correct. It's a specific date, but let's call it July 1. But we'll let you come in May 1 beforehand in order to do your fixturing. Now, the problem with that is you have to have everything else in the lease lined up. So you have to have your insurance, you have to have your permits, you have to have all of these things. A lot of people forget, and unfortunately they forget about insurance often, that you really want to make sure that you've got that all dialed in. Now, all of these things have knock-on effects to other dates. And so let me point out that there are a number of different types of dates. One is a specified date, as Howard just corrected me on. Okay, July 1, 2020 is a specified date. Another type of date is a contingent date. And a contingent date is based upon something preceding it happening. And so you can't define what that might be. And an example of that would be that the tenant gets possession on the date of delivery of the premises from the landlord. If the landlord's doing landlord's work, no one might know when that is. Or if it's a new development, they may not know when it's actually going to start. So we have to be very careful with that. And what landlords often do, and I know, Howard, you want to talk about this, they have a schedule to the lease that says must be filled out that has acknowledgement between the two parties of the specific dates, of the lease commencement date, the rent commencement date, and things of that nature. However, Howard, How many times have you looked at a lease and found that that has never been filled out?
Oh gosh, I would say 90% of the time.
Yeah.
I mean, I'm given, as you well know, I do rent collection work and I do eviction work, and one of the first things that I have to do is read the lease. And when I read there are a couple of things that I see on that letter confirming the commencement date or rent commencement date, whichever one. Often I see that letter is signed as part of the lease execution. People don't, they just sign it here, sign here. So they go ahead and sign something establishing a date. Although it's a contingent date, they sign it when the lease is signed, or they never sign it. So right. I have this problem on trying to figure out, let's see, when was the rent commencement? I don't know, because the parties never confirmed it.
Right.
That's a problem.
I worked with a client, and they had 30 locations around the country. And one of the things that we wanted to do, because we have a service called the Lease Management Service, where we put the lease important milestones into a software program and remind the tenants of those dates, such as when you have to exercise your option. We'll talk about that in a second. But in going through the documentation that the tenant gave me, I realized that the dates they had were not consistent with the lease. And then I went back to the landlords, and over 50% of the landlords didn't even have the right dates. And so we had to do this kind of forensic look back on various dates to find out really what did things start. And Howard, I've got another question for you. How many times have you seen that the effective date of the contract, not the lease commencement, but the effective date of the contract, is your first preceding condition to another date? And it says in the very first line of the lease, this lease is effective blank of blank, and it's never filled in.
No. Oh. I've got a case right now that has the date February blank 20 and blank. Has the blank filled in. So I have to now, granted, I can draw the conclusions. The effective date of the lease is really, from my perspective, unless the lease says otherwise, it's to identify the lease. So when I go back and there are amendments, sometimes it could be 4, 5, 6 amendments. And if you have an effective date, that's what you refer to, not a commencement date, not anything else, but the lease effective blank date. And it does, if you have a 5-10-year lease or longer, and there are, triple net leases that could be 20, 25, 30 years, there's often assignments, and that whole history can be really messed up.
Yeah, but I agree with you 100% that of all the dates, the effective date of the contract isn't necessarily the most important one, unless a lawyer who didn't understand what we just talked about wrote the lease and made the lease commencement the effective date of the lease contract.
Right.
But here's
before
the thing.
You go ahead. You go.
I want to talk about exercising options. Is what I want to talk about.
Before you, you go ahead and talk about that, and then I want to mention one of my favorite stories about crazy things that clients do with leases.
Sure. So in 9 times out of 10, the date of the lease expiration is contingent upon the lease commencement. And to exercise an option, most landlords will have that the tenant must notify the landlord X number of days, weeks, or months in advance of the lease expiration. So if you don't have the lease expiration correct, you could miss your option, which is a benefit to the tenant, to exercise a renewal or an extension of the lease. By the way, those two things are two completely different concepts. But
why do landlords put that in? Why do they limit the time period in which tenants can exercise the option?
I'll give you 2 reasons and 2 examples. So the first one is so that the landlord, if the tenant doesn't exercise the option, has enough early warning to go and relet the premises to another tenant. That's reason number one. Reason number two is so that they can deal with the sequencing of their lease. And that brings me to my story. And my story is about an automobile dealership. And this automobile dealership had a very long lease. I think it was a 20-year lease. But it also, on top of that, had 4 5-year options for 20 years. Now, in this particular case, the tenant also had a right of first refusal to purchase the lands. The developer, the owner, the landlord, found a developer that wanted to pay a substantial premium to buy this land in order to intensify its use significantly. The landlord took the deal to the tenant, knowing full well that economically it didn't make any sense for an automobile dealership to pay this amount of money for an automobile dealership. And the automobile dealership didn't want to build a multi-story mixed-use complex. They just wanted to have a place for their automobile dealership. So the landlord was very confident that this was going to happen. So the tenant said, don't particularly like that. I'm going to give up my ROFR. Okay. And the moment that the sale closed between the landlord and the developer, the tenant exercised all of its options because its options were not sequential and were not time limited. And most options are sequential, meaning you have to exercise the first one in order to get the second one, in order to get the third one. This particular case, it didn't happen. So what happened in that particular case is the developer who bought the land all of a sudden was sitting there with a 20-year tenant plus the remaining initial term. And that cost him a lot of money in order to make that tenant go away, in addition to the amount of money that he paid on the land originally. So that's a landlord tale, but also good strategic thinking on behalf of the tenant, because they did a great job just holding their cards and watching their negotiation. So that's why landlords have that in there.
Well, I think that there's another reason.
Okay.
Options are really only for the benefit of the tenant.
That's very much true.
All right. So the landlords, what the landlords giveth, the landlords want to taketh away. And they do restrict it in such a way. They don't want to really give too much of it. Let me do a quick, crazy tenant story, which I'm sure that you've heard me tell before. Before I became general counsel for Allied Education, for about a year, I was doing all kinds of legal work for them beforehand, most of which was lease negotiations. And I handled this lease negotiation for them in San Jose. And so the strikeout leases. This was in like 1985, I think. So what I did was it was like a 30-page memorandum. So I had in it, I have a problem with this language. This is what you should do, and this is why you should do it. So this was an attorney-client communication that not only had the changes, but our strategy.
Oh no!
And I never heard anything back. In January of 1987, I go in-house. I become director of real estate, and one of my first jobs is to organize all of the leases. And so I'm going through. I have staff, but I'm reviewing all of the leases, and I look at this San Jose lease. And what they did, the landlord and tenant signed, attached my memorandum to the lease, signed the lease, and initialed every page, because I told them initial every page of the lease, but initialed every page of my memorandum, which contained all of our strategy. And they just signed it.
And I have to ask a question. Did that effectively modify the clauses in the lease that you told them to modify?
Well, to the extent that it included strategies, it explained. I mean, we never had a problem with that lease, thank God.
Yeah.
But if there was any ambiguity in the lease, my strategy would have explained the ambiguity away.
Yeah.
So this was not to the benefit of the landlord. I can tell you about that. Let's move on now.
Yeah, let's talk about CAM charges, building operating expenses, utilities, and things of that nature.
Let's get to that.
And while we're doing that, just as we set this all up.
Well, before we get to the CAM charges, let's talk about premises description.
Sure,
this is important.
Very important. So the premises description is one of the 5 elements that is required for a legally binding contract. But more than that, it also deals with all of the financial implications for the lease itself. So in Canada, we deal with, we have 1 foot in both worlds. Generally speaking, we deal in square feet. Unless we're dealing with the government, then it's in square meters. But the thing that we need to bear in mind is that there's many, many standards of measurement. One of the most common, and you shouldn't be surprised by this, is that the landlord wants to maximize their inventory. And the landlord's inventory is basically 2 things: space over time. So the measurement will typically be to the exterior wall of any wall that faces onto common area or is not part of the landlord's property. And then to the middle of walls that partition the tenant's premise from another tenant's premise. So that you're actually going to get up with rentable area, which will be larger than what than you can use, because you can't use the interior part of a wall or the exterior part of the wall. So it's very important to understand the measurement. The other thing that is very important, and there are standards out there, and one of the most common is BOMA. But BOMA updates its standard from time to time. So from the tenant's perspective, you don't want to have the wording just say the BOMA standard measurement. You want to define what year that is. And the perfect example is that in 2018, BOMA updated its standard for office buildings. And it now includes patios that are in the air that serve a tenant or a set of tenants, as compared to a patio down ground. This could be a patio on the 15th floor, for an example. The result of that is that the average office building in North America grew by 4%. That means that the tenant paid 4% more in rent on average than they were in 2017. Yet nothing changed. So make sure that you put into play, and I can guarantee you, BOMA never goes backwards in its standards. So I can guarantee you that if any other revisions come along, it's important to have the date in there. And understand also the requirements for your particular asset class. For an example, in warehouses, it is typical not to the exterior wall, but to the drip line. And the reason that the landlords have the drip line is that if you have a loading dock, it may be covered. And so the drip line is where the rain drips. So the landlord will measure out to that so that you pick up all of that loading dock apron. And in some cases, you have a restaurant that will include a patio, and it may include the patio. You have to be very, very, very careful.
What is well, let's talk a little bit about the significance of what the premises are. And I'm going to use one example. One is, as you've discussed, the premises measurement or identifying the premises correctly can affect the amount of rent that you're paying. Mm-hmm. And that's very important. And often the lease will say approximately 2,000 square feet. All right. Yes. And what I prefer to do in the leases, particularly when I'm representing the landlord, is the parties can agree this appears to be 2,000 square feet. As far as I'm concerned, if I'm the landlord, look, you have determined on your own that this is going to satisfy your needs. So we are going to base the calculation on the rent on the square footage, but it's only our way of calculating it. It really, if we're off by whatever amount, it doesn't affect the rent that you have to pay. You have to decide that you're going to be taking these premises and you're going to be paying X amount of dollars per month or per year for the rent.
I'm not as nice as you, Howard.
Well,
in my negotiations,
that's obvious.
In my negotiations, I say that the rentable area of the premises will be the lesser of the certified area or the amount stated in the lease. And
I would never agree to that.
I know you wouldn't as a landlord, but you would do the same thing if you were in my shoes representing the tenant.
Absolutely.
I have a tenant right now that bargained for a space that was supposed to be 4,700 square feet, and he came in at, guess what, 5,200 square feet. That's 500 square feet more in base rent, in operating costs, in the proportionate share of property taxes, and everything else.
That was the other important thing that I wanted you to pay attention is how the premises itself relates in proportion to the rest of the building or the project or the property. And that's very significant. And why don't you touch a little bit further on that?
So it's one thing if the building that the landlord has is one contiguous building. Okay, it's a plot of land and one building is on it. But what happens if there are multiple buildings on the property and it's not a condo, it's just multiple buildings? You may have multiple measurements that you want to look at because there may be some costs that pertain specifically to the building in which the tenant is occupying. There may be costs that apply to the overall project. I'm thinking business park here when I say that, or a warehouse park. Or now we're seeing food dining parks, right? That's just a big conglomeration of freestanding restaurants. So you want to understand the interplay of all of those things and understand your cost risk for all of the different aspects of the building. There's another thing that comes into play here. It's not on your screen, so I'll just mention it, and that's gross up factor. And in a gross up factor, you find it mostly in office. You don't typically find it in warehouse or retail. But in a gross up factor, the landlord is going to gross up the rentable area. They could also gross up costs, but I'm going to talk about area here. Gross up the rentable area to account for things such as the lobby, the corridors and the hallways, all of those things. Because what does the landlord want to do? They want to maximize their inventory. And it's very important that you understand what that gross up factor is, plus also what are industry standards. Obviously, the lower the gross up factor, the more efficient the building. There's a building in Pasadena that I'm familiar with. It's kind of shaped like a donut, except it's square. It's got this big 6-story clear atrium topped by a skylight. The landlord was grossing up the air in the atrium on each of the floors. I don't think that's fair.
No, let's move on. Why don't you start with the CAM charges?
Back in the day, let's start by defining what CAM charges are in triple net leases. You may see it written as you do on the screen as NNN lease. That stands for the three nets: CAM, property taxes, and insurance premiums. Back in the day when I was a very young man and still had hair, what we referred to as CAM was common area maintenance. Over time, landlords have morphed that concept to include all costs of operating and in some cases even ownership of the property. And so the concept is morphed. It's really important to understand what your operating expenses are and how they play in. Now, in a gross lease, conversely, the tenant writes a check for one amount. They don't care how the landlord slices or dices it, what part goes to mortgage or utilities or profit. And in a modified gross lease, that's where it starts off at a certain amount. You just write a check for that. But then the tenant may be responsible for any increases over and above an amount for things like utilities, property taxes, snow removal if you live in Canada, and other things like that. So don't assume that everything is static. And one of the things that I keep telling people is you have to future-proof your lease. Don't take what's happening today to be the gospel as to what's going to be happening in the future. I'm going to give you a prime example of that very quickly and why you need to be very, very careful about what's included and not included. We have a concept of a tax in Canada called the capital tax. And the capital tax is a taxation on the landlord's capital or equity in a property. Depending upon what government is in at a particular point in time, this tax either comes into favor or goes out of favor. And right now we're in a period of time where the landlords can't charge a capital tax. So they don't get a capital tax charge, then they can't charge it to their tenants. If you're negotiating with me and I'm working for the tenant, I'll negotiate to take that out. The problem for the landlord, though, is when it comes back in, if I've taken it out, you can't charge the tenant back again. Now, otherwise, the landlords on the other end of the scale are going to say, I know I want to keep it in there because it might come back in the future. You want to be very careful about those kinds of things where the landlord's saying, well, it might happen. Well, if it might happen, let's deal with it then, not now.
Okay, Peter, we got to move on a little bit on this. Yeah. I want to get a couple of points in with regard to operating expenses, utilities, etc. Number one, if there's a title, and I've seen this happen a number of times, where a lease would say gross lease, don't believe it.
Yeah.
Because it's probably a modified gross lease. So it'll say gross lease. You may be thinking, okay, everything's included, but then there'll be all kinds of provisions inside the body of the lease that say, well, you're also going to have to pay this, this, and that. The idea of a gross lease is you have one payment, includes everything. But rarely do we see that. And if we see it, it's usually in office. But again, there are all kinds of exceptions to the rule. In the original version of this webinar, we did a poll, and I asked all of the attendees, how many or what percentage do you believe of the reconciliation charges are accurate? And reconciliation is where in many leases where the tenant is going to be paying building operating expenses or CAM charges, etc., the landlord will estimate on a going forward basis what they anticipate these charges are going to be, and then they charge the tenant on a monthly basis. And then at some point after the year is over, they will go back to a reconciliation, and they will either, based upon what they've actually spent, quote unquote, they will go back and they will either charge more or in some cases actually charge less and give the tenant a credit. We're not going to go into, we did a separate webinar on all this, so we're not going to go into this on detail. But one of the questions I asked was, with anonymity, how many of you believe that these reconciliations are 100% accurate, 75%, or 50% or less? And the vast majority, including landlords and property managers, all admitted that it was, the vast majority was 75% or less. Mm-hmm. All right. And now, granted, there were probably more tenants on the webinar than landlords, but it wasn't, it was more, I viewed it more as an admission. And that's one of the reasons why when I serve notices in California, I serve multiple notices, one of which is an estimated notice that I carve out for camp charges and building operating expenses, because I'm never confident that they are accurate on the reconciliation. And fact, by their nature, they're estimated.
Yeah, and you know, my experience has been is up to 80% of landlords' billings for CAM, property taxes and insurance can be incorrect. And it makes sense if you think about how complicated a lease is. And if you have a property with 50 or 60 tenants in it, they all have different leases. Some are included in some are included, some other costs are included in others. And you've got this poor lease administrator trying to make sense out of all of this and putting it all together. I'm not blaming anyone. It's just a matter of, we do deal with, as we said before, this common knowledge that, oh, it's all like this for everybody. You know, it's not. And, you know, you have a change in staff and then they go, well, this is the way we used to do it at this property or this company that I used to work for. doesn't necessarily apply. And that brings us around to tenant audit rights. Tenants should
Yeah,
have the right.
let's just touch on that
I'm
because
going to. Tenants should have the right to audit.
I'm going to refer people to our other webinar, which
Yeah.
goes into that in much more detail.
All I'm going to say is that tenants should have the right to audit the landlord's books. And as Howard mentioned earlier, the landlord giveth and the landlord taketh away. They put in a whole bunch of conditions in there, which I think you should try and get rid of in the negotiation so that, you don't have to use a big five CPA firm, and it doesn't have to necessarily be in the landlord's office and where the heck am I? So all of those things are disincentives to auditing. Just make sure that you get the broadest auditing rights you can, and watch the other webinar where we talk a lot more about this.
All right. So let's talk. I'm going to talk about the incorporation clause. The incorporation clause, and it often goes by other names. It basically says, look, if there were any other promises made, if it wasn't included in the written lease, it never existed. All right. However, in many jurisdictions, well, I'm not sure if it's many, at least in some jurisdictions, the courts in California in particular, the courts have allowed tenants to sue to either rescind the lease or sue for damages where the tenant was able to prove that representations were made to induce the tenant to enter into the lease. Mm-hmm. All right. So that kind of has that's a legal terminology. That has taken away, excuse me for not sounding so legalese, that takes away some of the enforceability of that incorporation clause. I want to move on now. All right. One of the questions I have for you, Peter, is, let's remind people. I want to remind everybody in the middle, this is where you can get in touch with Peter. He's at greensteadcg.com, and you can get a hold of me on LinkedIn, Howard F. Klein. No, it's just Howard Klein, I think. I'll double check. Look me up on LinkedIn. I don't want to belabor the point on this. I've got a question for you, Peter, before we get into the specific property types, but it's a good segue. How do you determine what clauses are most important and which ones are less important? Which ones should you dig your heels in, and which ones can you let slide? How do you make that determination? And then we can get into the specific property or asset classes, because that's part of your answer.
And it is part of my answer. It depends upon the individual tenant, and I'm taking the position of the tenant here. Depends upon the specifics of the tenant and what they desire for their business. And as I mentioned, when you go into a lease, you should be thinking about how you're going to be getting out of the lease as well. We actually did a webinar about the essential elements of a good negotiation. And we talk about the aspirational clauses, the aspirational aspects of the lease, as well as the critical, or this is the walk away point of the lease. So it's all about pre-planning and really thinking about your business and where you want to go with the business. And it will depend in some cases upon the type of business that you're in. For an example, in retail, exclusivity is really, really important. Having that co-tenancy, you're probably in a shopping center that has maybe a grocery anchor that draws a lot of traffic. What happens if they go away or they go dark? And go dark means that you can continue to pay the rent, but you don't have to operate. Think COVID-19. Relocation clause, very important, because when you are looking at retail, you're looking at a specific space that has specific attributes, such as visibility and traffic and parking. You don't want the landlord to move you around to the back of the building where you lose all of those attributes. So you want to, again, think about how important these aspects of the lease are to your business. And when you go into putting in your offer to lease, this is where you need a really good, and I do mean really good, commercial real estate agent, or we call them brokers, generally speaking, because they should be asking you these questions. And they should have the lease memorized of the typical clauses you would find in a lease and just walk you through on a checklist. Is this important to you? What's important here? Why do you need this? Signage, vitally important, not only to have it, you should have it for free, in my opinion, but also, is it going to be visible throughout the term? You don't want the landlord blocking it with another building or trees and landscaping or something else, where again, you're basically left to your own devices to get your consumer coming into your business. And parking. You don't want to be in a position whereby you have this parking field in front of you, and then the landlord gives it away to another tenant on a reserved basis. If you have extended hours, that parking should be lit. I have a client called Anytime Fitness, and just like their name, they're open anytime, except during COVID. And so they need a percentage of the parking lot lit. That's very important for the customers to feel safe. So again, look at your individual business. What do you want to get out of your business? What's important for your business? And by the way, what's important for a daycare is not the same as what's important for a coffee shop. So really understand your business before you sit down to negotiate. Prepare.
Yeah, mentioning exclusivity, the sister clause is a prohibitive use clause.
Yeah.
And I'm not going to go into detail on it now, but I will have a link that will be attached to this, to our webinar on prohibitive use clauses and its relationship to exclusivities. Let's move on now. Oh, this is where Peter gives his 40% discount to Master Guide to Leasing for retail landlords. As I mentioned before, this will be good for 24 hours to the first 20 people who will exercise this option and buy the book. And by the way, are you paying me something for this?
I am.
Are giving. Yeah, you're giving me a piece of the action for this. So, in full disclosure, I want everybody to know this. And in order to get it, I probably should have had it on the slide. You need to use the coupon code CRE Radio to get the discount. Let's talk about office and we didn't go into a lot of detail on office. I think probably specific clauses having to do with retail. You see a little bit more of the meat and potatoes on that, but here are some of the ones that have always caught my attention in office. HVAC and after hours HVAC. It's not unusual in an office tower for the HVAC to be in zones that might cover multiple floors. And as a consequence, the office usually only runs HVAC during certain hours. So if you run a business where you want to have after hours, you want to use the office after hours and you can't open up the windows, it's really important to be able to have HVAC running in those evening hours, etc. In those
like
cases,
a person from Nevada that never gets cold. In Colorado, you want that heat. Don't open the window.
yeah. Well, the example I use is I negotiated an office lease of multiple floors in Detroit. It was the vocational school chain that negotiated it, and most of our classes were in the evening. And the building for our 4 floors really covered a zone that was 8 floors. Mm-hmm. As a consequence, now we had to negotiate this, but it was very expensive to run the HVAC in the evenings. In the wintertime, you needed heat, and in the summertime, you needed the air conditioning. So that's something that can be really, really expensive. Access and security. Sometimes, yeah, same thing. They'll give you access during normal business hours, and then you have all kinds of security issues. Let's see, we've got janitorial. Janitorial is an issue. If it's a gross lease, it's usually included. But to me, janitorial also becomes a security issue. I had a tendency to work late at night when I worked at Allied Education. One evening, I was in the office working. I walked out. We had a full floor. And lo and behold, there was a security guard sitting at one of the computers. Mm-hmm. And fortunately,
I won't
I
ask what he was
was.
looking at. And then
No,
we have,
he was using it, but
yeah,
there I was, 6'2", 240 pounds, bench pressing, almost 400 pounds. It's a good thing he didn't have a gun.
yeah,
The operation of elevators, different elevator banks, really important, and parking in urban cores. Parking is always an expense.
yes. And one hint on that one from the tenant's perspective when it comes to parking. Don't agree to a mandated number of parking stalls because your
Oh,
staff complement may go up or down. And what we're finding with COVID, briefly touch on that, desk hoteling and hot desking have come back into vogue in conversation. We don't know what that's going to look like yet, but you don't want to have to pay for 30 parking stalls if you're only ever going to be using 15. So just bear that in mind.
you want to have the flexibility.
Exactly.
Yeah, let's move on. Industrial power and hazardous waste are always huge issues.
Yeah.
Industrial. Um, you also have the issue of egress and ingress, but that's usually something that helps you determine whether or not you want the location or not. Power is also something that you have to consider, but it really depends upon what's being negotiated. But power and hazardous waste is always an issue. And in industrial, as in perhaps sometimes in retail, you may need to get phase one information.
Yeah.
Excuse me.
Yeah, environmental generally, and it's not just hazardous waste. I don't want people to just think about the hazardous waste that is produced during the tenancy. There are environmental things beforehand. And when we're talking about environmental, let's make sure that we're understanding that we're not just talking about things like asbestos, but we're also talking about mold. We're talking about radiation, radon gas, all these other things as well. Some other clauses that are going to be important in it. What I want to talk about in this one, because there's a lot of work in here, and we could do a seminar just on incentives and construction. There's a couple of things though that I do want to make sure that we touch on, and that is the sequencing of the negotiation is exceptionally important for the tenant. If you negotiate the base rent after negotiating incentives, the base rent's going to start at a higher number. So you want to negotiate the base rent first and then say, okay, what incentives are included, and then negotiate your incentives afterwards. So you want to really look at the sequencing. Just as we talked about with assignments, you may want to hold some of those cards back until you assign, and then worry about your liability at that point in time. The other thing on construction, though, I do want to make a mention of this. Make sure that in your offer or a letter of intent that you have a permit contingency, because you may find that you can't get a permit. And we talked about fixturing periods beforehand. You don't want that fixturing period to burn off before you can even get in. Or it may not even be feasible for you to build. I know of a case where there was a change of use and the municipality said, there's no sprinklers in this building. If you're coming into this building because of the change of use, we want you to sprinkler the entire building. It became economically unfeasible. This particular tenant, unfortunately, did have a permit contingency. So they had to negotiate their way out of that lease.
Yeah, we could do probably 2 or 3 webinars in terms of construction, work letters, and a number of other factors that come into play. And we'll probably schedule those over a period of time. So we're just touching on those. Whatever you do, construction, landlords construction, obtaining permits, contingencies, ADA compliance, all of those issues. It's really a complicated issue. And this is one of those areas where you not only need an attorney, you probably need an architect to help you. All right.
Oh, sorry, go ahead.
No, go ahead.
I was going to say one last thing on incentives. I see it up on the screen, and I should have mentioned it earlier, which are clawback provisions. Many times landlords will claw back an incentive if anything happens. We talked about, having an option that's personal to the original tenant. If it's assigned, then that goes away. That's a form of clawback. Another clawback might be that if the tenant is in default, they have to pay back all of the commission or the unamortized leasehold improvement allowance, which I think is wrong. But anyway, those are all those things. You got to be aware of them, and you've got to negotiate them. And if the landlord just puts it in, don't take it as gospel. No, negotiate.
Yeah. Rules and regulations. Let's touch on this. And we had a webinar that included Jerry Neitlich, and he was making a point, and this is very, very true. A lot of times the rules and regulations have all kinds of limitations in it and requirements that are not included in the lease. And tenants have a tendency to just gloss over those rules and regulations. Do not gloss over it. It as an attorney, I have to read a lease a minimum of 3 times because I have to know and understand every single word. And I know that when I make the assumption, the word assume is a 4-letter word in my office. Never assume. Yeah. Right. So rules and regulations, you have to be very, and I'm not going to even allow you to chime in on this because we only have 5 minutes left to, we'll get into,
because I can go on forever. Let's talk about COVID.
Now, yeah, let's talk about COVID. And these are clauses that have already been in leases, but to a great extent, a lot of people haven't paid attention. Yeah. You want to mention force majeure? Because everybody's making this big deal about force majeure. Yeah. And I put it on the slide along with insurance because they are very related. Go ahead.
Force majeure is a French term, and it means a major event, just almost literally. And 9 times out of 10, it would include things that basically say if it's out of the control of the particular party, the landlord or the tenant, the landlord or tenant are excused for the period of whatever time they can't perform from performing that particular item. Almost all leases to date in the boilerplate clause is said that applies to everything except for the payment of rent. And so what has been happening is that landlords in the age of COVID are saying, you may be prevented from opening and operating. We'll excuse that in certain aspects of the lease where you are required to do those things, but you must still pay the rent because you're not excused from doing that. So force majeure, I think, is a clause that's going to come under a lot of scrutiny. I think we're going to see new ways of writing it as case law comes together and as people get creative on trying to deal with pandemics. And by the way, in many cases, if it did not say pandemic and it specifically outlined what is an item of force majeure, if it isn't included, then you're out of luck. I want to briefly, along that line, touch on abatement versus deferral. An abatement of rent is where the landlord forgives the rent indefinitely. And a deferral is the landlord says, I'll forgive the rent for now, but you have to pay it back later. The one thing I would want to caution all tenants on is if you agree to a deferral, 2 things. One is make sure that your overall gross rent occupancy cost or rent to sales ratio, and every business has one, doesn't blow up as a result, because then, you may have survived COVID, but you may not survive 6 months from now because you're having to pay back the rent and it's just not economically feasible. The second one is with respect to the deferral, is have it over the longest period of time you possibly can in order to be able to keep your rent to sales ratio consistent. I've heard of landlords saying, I'll give you 3 months of free rent, but you have to pay it back in the next 3 months. That could kill a business. It really could.
Yeah, we'll have a link to our separate webinar discussion on that topic. Let me handle the issue of insurance, because insurance, first of all, you're hearing about a lot of lawsuits against insurance companies saying that, the tenant thought that their business interruption insurance covered this type of event. I suspect that, most insurance experts will tell you, no, it doesn't cover. Most business interruption insurance requires some sort of physical damage. I don't know if that's going to hold up because there are going to be many, many lawsuits. With that being said, there have been additional riders that some tenants and some landlords had thought of that would have specifically covered a pandemic. And so I have questions whether or not these lawsuits, and depending upon the jurisdictions, that the insureds are going to be successful. But I am confident that people are going to pay attention to this, and there should be business interruption insurance, and you're going to be seeing situations in which the landlord will require the tenant to have this type of coverage. It'll protect everybody. May be expensive, but it'll protect everybody. And I think that the landlords should consider having broad enough coverage to cover this type of situation also. Because hopefully we won't have to worry about the landlords filing bankruptcy or the tenants filing bankruptcy. We might then have to worry about the insurance companies filing bankruptcy, but hopefully the insurance companies will handle their underwriting in such a way, and they usually do since they're experts at it, figuring that they'll be able to make money.
One last really quick comment on COVID and the lease. What has come up is that there are what we call boilerplate clauses. These are clauses that even lawyers look at the title of the clause and say, oh yeah, this is standard. And they don't really dig into the meat of it. One would be force majeure. Another one would be eminent domain. Another one, to a lesser degree. I mean, I see more negotiation around insurance, but basically a lot of people don't touch insurance because it's dictated by the finance company or others. But I think that all of these clauses that we've taken for granted as boilerplate clauses now need to be looked at in detail. Don't gloss over them just because someone says, oh, it's boilerplate.
Insurance clauses are not my favorite to read. And I'll be frank on that. So the world is changing. This will have links to our other webinars. If you're watching this on YouTube, you'll see links within this. I'd like to thank you for watching this webinar on behalf of Peter and I. Peter, thank you very much.
My pleasure,
and you and I will have a conversation about the other webinars that we're going to be doing, which will include probably one on work letters and construction. And I'm going to be doing one on guarantees because that's coming up in a lot of the discussions that I'm having. So, with that being said, Peter, thank you very much. You did a wonderful job.
Always a pleasure.
Well, everybody, be safe and be healthy. You take care. Bye-bye.
You too. Bye now.